Okay, today we're going to talk about constitutional law a little bit more. I'm probably going to skip over, I could talk about First Amendment all day long. It's my favorite topic, actually, to discuss in Constitution. But quite frankly, the odds of y'all getting involved in, I mean, maybe from an employee standpoint, you get punished for something you say or those kinds of things. Um, it depends. But if you're working for a private employer, or the army, military. Some of you, a couple of you are on were or are in the military. You're not in a democracy in the military, right? You're in an institution of democracy to protect democracy, but to protect democracy, you have to be sometimes undemocratic. So, you know, you can't talk about Biden or Trump or whomever because there's a commander in chief and you're in the military and you're not supposed to do that. What you do with your spouse or your buddies around the bar or the water cooler or at home or whatever is a different matter. But in terms of, going out on Twitter and putting the president on blast or something like that, or X, excuse me, not Twitter anymore, or something like that, you can get punished for that. Neighbor's dog. Um, the thing with the same with religious stuff, mostly again for you guys, mostly from an employee standpoint. Now there are both state action, which is where the 14th Amendment comes in, versus private actors. Usually there are federal laws. So there's the Constitution, which prevents state action, as it said. So the Constitution, I don't think I've said this in this class, the Constitution limits the government. Contract law, criminal law, civil law limits us. So the government can't touch my life, liberty, or property without due process of law and or my consent, etc. Right? First Amendment up in here, Fourth Amendment, property, etc., etc. But you can't either, right? We can't touch each other's or interfere with each other's life, liberty, or property without consent, contract, those kinds of things. And then there are some areas where Congress and states have passed legislation that protect those things from private action also. So, for example, if you are going to UCR, University of California Riverside State Institution, they cannot, make you do something against your religion. Generally speaking, we can obviously you've seen clashes between that in regards to bakers and gay marriage and those kinds of things. That's really beyond the scope of this class, sadly, in terms of discussion wise. But they can't make you work on Sunday if you are a devoted, what we call a Sabbatarian, right? You have a Sabbath, or if you're Jewish and Saturday is your holy day, or if you're Muslim and Friday is your holy day. If you work for McDonald's, McDonald's probably can't do that either, right? So, but the UCR can't under the 14th Amendment. McDonald's can't under some other federal law, the some Civil Rights Act of, I think, 1990, if I remember correctly, and the Civil Rights Act of 1964, right? That prevents private actors from doing that. And then the exception would be, for example, Cal Baptist or Cal Lutheran or Baylor University or Notre Dame, right? If Notre Dame wants to hire all Catholics as faculty, they are more than able to do that because the First Amendment protects the rights of the Catholic Church and University of Notre Dame to protect its religious identity. So, for example, if you're going to teach at Cal Baptist, you're supposed to be, that's what they tell us, ideally we'd all be Baptist because it's a Baptist school, but if, being this is California, there's not a lot of Baptists. That's why they import us in from the South and from Texas. We can discriminate legally on certain things, just religion based, not race, gender, etc. Right, all that sort of stuff. So the strict scrutiny parts here, so on the slides 17, 18, 19, it depends on what basis the state is making a decision. So if the strict scrutiny test is for things that are explicit in the Constitution, so the 14th Amendment, right, race, religion, color, national origin, right? And then the court also looks at what they call fundamental rights. So First Amendment, Second Amendment, guns, Fourth Amendment, property, Fifth Amendment, and Sixth Amendment, trial, all those rights in the Bill of Rights. If the state is trying to limit those, it has to show that it's it's necessary, like they have to do it. A couple of weeks ago, and if you don't know what I'm talking about, it's because you're not watching the videos. if you even made it this far. I made the ridiculous example of me trying to infiltrate like the Mexican mafia or Boko Haram, this Nigerian group. And I'm not Nigerian, so the government clearly is not going to hire me to infiltrate that group. They wouldn't accept me. I'm a white Christian from the United States, right? So, but that's that's what strict scrutiny means. It's got to be something like that, right? In the military, right, they pretty much limit your free speech. Why? Because you have to have, a esprit de corps. You have to have military discipline, chain of command, all those kinds of things that are good things. We should probably have some of those in the private world, but in the military, they're necessary. They're required to do that, right? You can have some, you need it's a balance, right? You need someone lower down who can sometimes question authority above, of course, but there's a right way to do that, and there's a wrong way to do that. And so they limit your speech there on that. If it's what's considered a quasi-suspect class, so for example, you get intermediate scrutiny. So there are some things, I know it's popular today to say there's no differences between the genders, but that's literally not true. And so the question is, how important are those differences, and on what basis do those differences justify differential treatment? They don't in terms of pay. So if you're doing same pay, same job, same person, so school teachers, right, a fifth grade school teacher who's a female should get the same pay as a fifth grade teacher who's a male, right? Equal work, equal pay. I know somebody wrote, a couple of y'all wrote on the issue in terms of sports and athletes. So for example, and I just watched a clip of Serena Williams the other day giving an interview, I think from a few years ago, and she was talking about how women's tennis is a completely different sport than men's tennis, right? Andy Murray had jokingly challenged her to a match. He was a British player who won Wimbledon a few years ago. And she's like, well, no, he would like kick my butt all over the court, right? Because he's faster, stronger, he serves at 150 miles an hour or whatever. It's a different sport, right? They play 3 sets and all that. So I'm not saying those are right or wrong, but those are the bases upon which, at least at one time, tennis, the winner of women's Wimbledon got less money than men's Wimbledon. It was literally less tennis, based on just the amount of tennis played and revenue brought in. But people like Serena Williams actually increased the revenue, and so anyway, that went into the pay issue. But you have to provide justification. You can't just say, boom, men get more than women or women get more than men, and that's it. You're going to have to, if you get sued, you have to show this aspect. Illegitimacy doesn't really matter much anymore in terms of whether someone's married or not when they're born. Alienage, which refers to someone's visa status. Are you a citizen, a resident, alien, an illegal, undocumented alien, someone who's here against the law? Are you on a work visa, student visa, tourist visa, all those kinds of things. Immigration law is a huge area of laws, you might imagine, not just politically, but all of that. And so, for example, I just saw a thing where I think where City of Chicago said that people who are undocumented illegal aliens cannot be police officers. The federal government says that's not possible, so Chicago, that's fine, I guess. They can do something, and they can hire whoever they want. But the federal government has said you cannot be a gun-carrying police officer in the United States if you're not a citizen, right, or a resident alien. You're here legally, you got the proper papers and a work visa, all that sort of stuff, right? You don't want to hand out guns to people who have no idea where they come from necessarily, their background, and all those kinds of things. So the federal government has said that's not gonna pass, and so they provide what? They have to provide justification. They can't just say no, right? They got to provide that if there is a lawsuit that comes in. The second one, the third one is, and it's not really in here, it's called rational basis, and that's pretty much for every other discriminatory act. So the most common example there would be like test scores. So if you didn't have to take the GRE to get here, praise Jesus, right? And of course the GRE is kind of falling out anyway. But in the old days, you would say, well, okay, well, on what basis are you choosing students? And you'd say, okay, well, there's kind of a matrix of things here. What's their GPA? Maybe where they went to school. Obviously, what are their extracurricular activities? Test scores, right? So higher test scores, higher GPA. So I went to law school. It was LSAT. test, which is, and GPA. Those are the two main ones. There are other factors, but those are the two main ones, right? Has nothing to do with age, has nothing to do with race, nothing to do with gender, all that sort of stuff. The reason they had those kinds of tests was to basically try to get away from that kind of discrimination. The equal protection claims in it's EPC challenge, equal protection clause. Initials don't do well in online classes. I didn't make that. De jure is means from the law, discriminatory purpose, but most of the time, probably again the obvious example there would be, and you may have all seen them in history classes or documentaries, like the old school, just sort of straight up racist Jim Crow, like a white swimming pool, colored swimming pool, white restroom, colored rest, right? I mean, it's in your face, in the law. I mean, it's pretty explicit racial discrimination. That doesn't really happen much anymore because, one, obviously that's outlawed, and two, it's culturally, people just don't get into that, thank God, anymore. I won't put up with it for the most part. And two, there are some people who would, of course, do that, and they're smarter than to just sort of put it. So the hard part is kind of sniffing it out if it's not explicit. That's called de facto. And so that's where you, you have it in the law, the purpose is discriminatory, but you don't put it in the, so for example, and I'll just use the disability example, sorry about that. If you put in there must be able to run 5 miles in a secretarial position, right? For the sole purpose of you just don't want to hire someone who's disabled because you think it'd be a hassle and blah, 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 whatever the reason, right? And you say, okay, well, how is 5 miles running related to secretarial work? Like, what's the connection? And the answer, of course, is there is no connection. That's a way to discriminate against disabled people without actually saying, I discriminate against disabled people, right? So that's called de facto discrimination. It doesn't express it purposely or explicitly, but it is there. Affirmative action programs, and there was a big Supreme Court case this last year, the last term coming down, which basically struck down attempts by Harvard and California and other schools to discriminate against Asian students. Actually, was the targeted group there, and so it was filed by some groups representing Asian American students because they were getting basically excluded from schools for people with lower grades, lower test scores, and all that sort of stuff. So affirmative action is racial discrimination. It's basically racial discrimination to resolve past racial discrimination. So that's the way it was offered up in the 60s, especially if you think about coming out of 100 years of Jim Crow. If you're African American, you can't, it's not that they're not letting you into law school, they just won't even let you apply to law school in some states, right, or med school. So you do have this dearth, I guess, underrepresentation of Black Americans in the professions, especially, right? Teaching, nursing, doctors, lawyers, accountants, etc., that kind of thing. But also even, think about just other lucrative jobs, truck driving, union, electrician jobs, factory jobs, and all that sort of stuff that are good pay, good benefits, and all that sort of stuff. So affirmative action was put out initially to sort of remedy that. So I'm not sure what the full impact of the Supreme Court case will be beyond education, but eventually you kind of like any pathology, you're supposed to get off the medicine at some point in time, and so that's really one of the major debates about affirmative action has been. Is like, okay, when do we stop? Because if racial discrimination is bad, it's either always bad or it's sometimes good, and then how do you determine if racial discrimination is ever good? Is kind of the inherent moral hazard of affirmative action. Due process, when you see that, due process basically just means fairness in process and notice of why you're being disciplined or whatever. So if you work for a government agency, school district, state university, county hospital, county clinic, that sort of thing, even if you get fired or let go or whatever, they have to tell you why, and usually there's a hearing opportunity, right, an administrative process before you sue. That's part of due process. What process are you owed under the law? Anyway, there's a whole semester, 2 semester classes on constitutional law, and I have blown through that in 15 minutes. Anyway, so if you have any questions again, feel free to put them in the discussion board, and I will answer them there. Thank you.